Good afternoon, everyone. Welcome to today's training, which is Ensuring a Workplace Free of Harassment and Discrimination, presented by AlphaStaff as part of our free AlphaStaff monthly webinars. Some webinar housekeeping. Please ask questions. You can use the chat feature and they'll be answered towards the end of the training. We also have all our previous webinars recorded, available on demand on alphastaff.com. You can access them by going to client resources and then clicking on business training webinars. A little bit about myself, who's your presenter today. My name is Jamshed Khan. I'm an HR account manager, and I've been doing this for quite a while, and I provided consultation for employers in various industries: medical, legal, financial, academics, different types of manufacturing. And the one thing I've noticed is that this continues to happen. Although we train employees and managers, this topic comes up. If you look at the news today, the Me Too movement, what's happening recently with some of the individuals involved in politics in key positions. And the takeaway from this is that it is not the intent, but the impact of what you say or what you do that matters. I've seen many different individuals affected by this. I've seen careers be compromised, livelihoods compromised. I've seen individuals who have lost everything. And I've also seen, on the worst case scenario, businesses that have gone out of business because of this reason. A really big lawsuit can severely cripple the bottom line and impact those individuals in the financials of the company. So I'm hoping this training is going to provide you some education and how to make sure that you implement a practice that is preventative. The agenda today is we're going to discuss the law around harassment and discrimination. We are going to define harassment and discrimination and discuss what are the impacts on your organization, how to prevent harassment and discrimination, and some corrective measures you can take to make sure this is not happening in your workplace. A friendly reminder before we start the webinar that this is a safe environment for everyone, that all questions are welcome and there are no dumb questions. Please do not take any names if you're discussing any scenarios to ensure confidentiality. And although you may not agree with everything, the purpose of this training is to have your compliance with the law and also to educate you. Once we complete the training, you'll have an understanding what harassment is, who can be a victim of harassment, how you can identify and address inappropriate behaviors, what you can do to avoid illegal conduct and to manage a harassment-free workplace at your companies, and how to appropriately respond to a harassment complaint when that happens. Let's take at some of the laws regarding harassment and discrimination in the United States. The parent of all laws, which was back in 1866, was the Civil Rights Act of 1866. That started this. Civil Rights Act of 1964 gave birth to Title VII, which created protected classes, which was race, color, religion, sex, or national origin, that you cannot discriminate an individual who belongs to any one of these classes. Americans with Disabilities Act, which came out in 1990, basically made it prohibitive to discriminate somebody based on their medical disability. In 1993, the EEOC enforced these protected classes and the laws governing them so that their workplace is free from harassment and discrimination. And then we have USERRA, which is the Uniform Services Employment and Reemployment Rights Act 2000, which basically made it prohibitive to discriminate anyone based on their veteran status. Specifically, laws that prohibit workplace discrimination are Title VII, which we discussed, the protected classes. We have the Pregnancy Discrimination Act, which makes it illegal to discriminate based on a pregnant. Equal Pay Act, that men and women should be paid equally for the same type of work. Americans with Disabilities Act, we discussed. The Genetic Information Non-Discrimination Act, GINA, which basically stated that you cannot discriminate against somebody based on their medical history or perceived medical history in their family. We talked about the Age Discrimination Employment Act, which is preventing anyone from discriminating to those who are over 40 in age. And then there are various state laws that govern, or additional state laws that might be governing the harassment discrimination. So when we look at the list of all the federal protected categories, we have your age, which is 40 and over, national origin, religious creed, disability, pregnancy, race, sex. Let's talk about discrimination. What is it? Is we all are discriminatory by nature. We might prefer Diet Coke or Diet Pepsi. We might prefer Buffalo Bills or Green Bay Packers, right? So one car or the other. So we always inherently have a preference to one thing over the other. However, when we treat individuals based on one of those protected classes that we discussed, rather than the individual merit, then that is discrimination. And harassment is a form of employment discrimination. Why is it illegal? Well, it is unfair, right? When you look at what happens in the workplace, you are creating an environment where you might be having a hiring practice where you're overlooking the skill sets, the individual merits of a candidate versus something that is out of their control. A predisposition that's based on belonging to certain race, color, sex, religion, etc., etc. If you have managers who are enforcing these illegal hiring practices or employment practices, then you may have limited access to that one candidate that you might be looking over and has been passed over, who might be the one who might make you that great product that'll take your company to that next level, or provide that new service that'll bring you all these clients and sales will boom, et cetera, et cetera. So for many different reasons, but number one reason here is that it is unfair and it is against the law. So what is prohibited by these discrimination laws, right? So if you're making any employment decisions on individuals that are, again, not based on their own qualifications for the actual quality of their work or their abilities to do that job, rather based on any protected class, it is prohibited. For example, this would be where documenting is something your HR professionals would be recommending and strongly implementing as a practice, because this is how you can show that you did not promote somebody based on the protected class. For example, you did it because they deserve that promotion, right? You had a way to document their performance and apply disciplinary action equally against everybody who violated a policy, regardless of the performance. That is very key here. So, for example, you may have somebody who's a single parent and they come in late every day, they have attendance issues, but they're great performers, high performers. And you have another person who's, let's say it's somebody who doesn't have a child, never been married, and they're not so good with their performance. You might tend to be a little bit more lenient to the individual who is single parent and has, let's say, issues with daycare, childcare, etc. And because they're performing well, you're allowing them to violate the attendance policy. However, the other individual who may not have a child, who may not be married, etc., you may be more strict with them because of the performance, regardless of whatever reason they have for having attendance issue. That is perceived discrimination. You cannot do that. You have to be fair and consistent across the board with everybody. You also cannot retaliate against somebody who's engaging in a protected activity. So, for example, somebody who's taking part in an investigation or a witness to a claim of harassment and discrimination has occurred. You cannot retaliate against them. You cannot change the job position. You cannot have any adverse action regarding their employment at your company. And we'll talk about that a little bit more later. You also can't have a different performance measure for an individual doing the same job as another individual. That might be discriminating, right? So equal expectations, fair and consistent across the board for the similar positions. Additionally, organizations cannot discriminate in their recruiting, hiring and testing, firing, promotions, transfers, discipline. We talked about that a little bit earlier, training, compensation, and benefits. So when you have two individuals and they're performing the same type of work, again, regarding a performance, which is documented, and you can show that, and you've recorded it, then you can give different pay to the individuals, right? When you're hiring somebody, based on maybe their experience, they might have longer experience than the other individual, might have more degrees specific to that job that they're being hired for, then there might be a reason to have a different salary for them. we're going to talk about harassment a little bit. So what is harassment defined? Well, it's unwelcome conduct, right? Based on one of those protected classes. Okay? So for example, is dating somebody or asking somebody to go out on a date, a coworker, is that harassment? No, it's not. It's when that becomes unwelcome. So simply, a coworker asks another coworker out on a date, the answer is no, and that's where it should stay. Okay? If that persists, then it becomes unwelcome. Simply by saying no the first time, asking again is an unwelcome act, right? So that's when it's unwelcome conduct. And it becomes unlawful when it's offensive, or let's say, it becomes a term of condition of employment, right? If you go out with me for dinner, then I will hire you for this position. Or I'll give you this promotion. Or I may not do the disciplinary action against you. And when that conduct becomes severe or is pervasive enough, it might create a hostile work environment. We'll talk about that. So how can the employer avoid liability? Well, they can take a very proactive approach rather than reactive approach, right? To prevent liability. They can have trainings. They can, educate your managers and supervisors about what the policy is. I assure you, if you don't, there will be somebody who will know the policy better than you. Make sure you're aware as managers and supervisors, 50% of the time, you are responsible in managing your team. The other might be doing your own job that is specific to your field. However, you have to be visible. You have to have an open door policy to anyone who is going through a harassment discrimination issue, and making sure that you are taking control of your own actions, right? Because you can control only what you can do or say. You can't control what others do or say. So by leading by example, you can prevent liability. Supervisors and managers, you're the frontline defense of the company. Hopefully through these trainings, when you see this happening, you can take a proactive approach and not turn the other cheek. There's a case that comes to mind. I don't know for those of you who watch football, but Jerry Sandusky and Joe Paterno from the University of Penn State, right? So what happened there? One person, great record as a coach, students loved him, decades to come, such a winning record, and all that tarnished because what did they do? Nothing, turn the other cheek. So try not to be that person. If you see something happen, as uncomfortable as it might be, it might prevent you from having something even greater occur negatively in your organization or your workplace. Also, managers and supervisors, you are responsible for creating a healthy work environment free from harassment, discrimination for all your employees. You have to keep be aware of these non-employees, vendors, sales reps, any external customers, clients, partners, vendors, relationships that might be coming through the door. How are they treating your employees, right? If you take a proactive approach and you're aware, you see something happening, it is your responsibility to remove that environment from the employee, not your employee from that environment, because that would be an adverse action against them, and that would be against the law. So we talked about familiarizing with your policy, but you also should educate and remind others of what the policy is. Every year, make sure through your HR team that the handbook is updated. Once it's updated, how are you sharing the information? Maybe hold a handbook rollout meeting where you go over major policies, and then they can acknowledge that they received and updated their policy. Right? That would be one method. Anytime, depending how the issue is, let's say there are some tasteless jokes that are circulating. Maybe that's a good time to remind them what the policy is, provide a copy of that policy specifically, than to jump to the write-ups, etc. Right? Again, this depends on how severe that or pervasive that issue is. Everyone has the right to earn a living, right? We all have the right to have a fair treatment at work. Life happens to everybody. And a lot of people spend most of the time working. They're loyal to you. They expect in turn for you to treat them fairly, okay? Harassment affects everybody, not just the individual who might be going through it or the one who's causing it, but think about your team. If somebody's having a attendance issue because they don't want to show up because they're going through something like this, then somebody else will have to pick up the slack. It might be overtime costs, morale issues, productivity might be affected by it, right? Or it might be a volatile situation that might be unsafe for individuals. You have to think about that as well. And if you're a company or a manager or supervisor who is not enforcing or promoting this type of culture where it's preventing the harassment discrimination, then employees might lose trust and loyalty to the company, right? And they might not respect you. Don't assume that it's just women or it's just men. Historically, women have had a lot of cases filed for harassment, but men and women can, on every level, be a harasser or a victim of one. Here's some good examples of harassment behavior. The first one is negative comments about anyone's religious beliefs. Religion and politics should not be a conversation in the workplace, unless obviously you are running or campaigning for somebody, and that is the business, right? So talk about their age, birthplace, ancestry, even though it might be perceived that the person might belong to somebody else. You never know who that individual might be related to. So even a harmless joke, and we'll talk about that later, might impact somebody else. Comments of somebody's skin color, right, or ethnic characteristics. Obviously, the racial derogatory words that we might see in the media, we might laugh about it, but this is not a laughing matter when it comes to work. Some examples of verbal harassment are, threats, intimidation, people telling jokes. Again, you don't know what you don't know. Two individuals telling a joke, you might think it's okay because it's not affecting them, because the perception is that they belong to a certain class and that other class is not there, so it might be okay. Well, you never know who might be listening in and how that's going to impact them. So be aware of that. There's nonverbal harassment examples, staring, right? Just be careful, right? Elevator eyes, things like that. Standing over somebody while they're working in a hostile manner, intimidating manner. And when people are being singled out, when they're being invited to, let's say, after work events, voluntary events, or lunches, things like that. If you have an employee who's being singled out all the time, or if you're, that might be a form of nonverbal harassment. The last 10 years or so, social media has really taken the world in the communication by storm, right? So you have Twitter, Facebook, Instagram, Snapchat, et cetera, et cetera. And these are all great medias for people to, bridge that communication gap. And however, it's also a stage where, for some reason, people choose to share inappropriate comments, sexual comments, maybe. Maybe they're harassing a coworker out for, a date, anything like that. And people, once you make a comment on social media, you might delete it, but historically, that stays, and you never know who's seeing it. So educate your employees about social media so they're aware of using common sense and good judgment when making posts. Hourly employees, even though they might be off the clock, if it's impacting the workplace, they can be held accountable for it. Hey, I didn't know it was 6 p.m. and I worked only till 4 p.m. So I went on Facebook. It has nothing to do with work. I was at home making a comment. No, if it's about a coworker, or supervisor, or manager, or the company also, it is going to impact the workplace and they will be held accountable. Let's shift gears a little bit and talk about sexual harassment. So sexual harassment is a form of sexual discrimination that violates Title VII of the Civil Rights Act. There are two types: quid pro quo, which means this for that, hostile work environment, and it is defined as unwelcome sexual advances and requests for sexual favors or conduct of sexual nature that affects that person's employment. It will affect their work performance or creates an intimidating, hostile work environment. Quid pro quo we talked about, which is this for that, is again unwelcome sexual advances when submission to such conduct is made either to imply a term or condition of individual's employment. So that if they subject themselves to that sexual act or request, then they will, it will change the term or condition of employment. Or when they reject that conduct or the request of such a conduct by an individual, that cannot be used for employment decisions, right? Again, if you go to dinner, if you go on a date with me, et cetera, et cetera. A hostile working environment is simply where an environment is so severe that a person would rather leave or voluntarily resign than to endure that. So it's based on unwelcome sexual conduct, and it often has the impact of altering the person's conditions of employment that we talked about, or their ability to do their work. So this is more common. Quid pro quo happened quite a bit historically. Now we see a lot of hostile working environment situations, and you want to take every measure as a supervisor or manager to avoid a hostile work environment. Some facts about sexual harassment. So 30% of women and 20%. That's interesting, right? They have experienced sexual harassment. About 15,000 sexual harassment cases are filed each year. As you can see that it costs companies quite a bit of money. And as of recent, men's complaints have tripled more than women. I think I started this seminar with the impact versus intent comment. Again, it is the victim's perception. And so it's not whatever the intentions the individual has who made the harassing or discriminating comment or act, or it's not their intention. Again, it's the impact of that act. According to a survey done in 2011 across companies of various types and industries, 32% of the employees surveyed did not want any type of sex talk at their workplace. 30% did not want any type of touching at all in the workplace, and 28% didn't want any type of sex actions in the workplace. The other survey deals with race, other race-related and other, but as you can see, that's quite a big number. So if an employee comes to you, right, and or you're trying to get to the supervisor manager, well, how would I know what is unwelcome? Because sometimes the language might be blurred. Well, first example here, and if an employee comes and complains to you, you need to stop and drop in whatever you're doing and document that so you can address the issue. You don't want to snowball into something else that becomes more expensive that your company would have to do. Sometimes people may not be open to complaining or verbally come and try to address the situation as a manager or supervisor or organization. Sometimes it's not saying anything, right? This can be seen in bullying environments, or when an individual feels that they do not want to disrupt things, right? Or it might be going against the norm in the company, right? They don't want to be that person singled out. So it doesn't have to be a verbal response, could be non-verbal responses. You can tell a lot by the facial expression. You can see if something's bothering an employee or not. Or when you're saying something that's bothering somebody, so look out for these signs in their body language. Are they, are they getting tense? Are they pacing back and forth? Are their hands going in a fist? And are they avoiding you or the individual altogether entirely? That would be another indicator of, that there might be some behavior that's unwelcome. Anybody can be harassed, right? It could be coworkers, your supervisor, your managers, your management, the business owners, key members, outside vendors, customers, anybody. Again, it is company's responsibility to provide an environment safe and free from workplace harassment. So it's very important to foster a respectful environment. Make sure you have a clear statement against harassment and discrimination. Typically, this is in your your handbook policies, and be that person who walks the talk. You want to make sure that as supervisor and manager, you're promoting compliance, and you have a good understanding of what your responsibilities are as a supervisor or manager. If you don't, reach out to your HR partners to get an idea of what is your role in a harassment discrimination claim. Make sure everybody's rights are protected, yours especially, and make sure you respect everybody. Treat everybody with respect. It's such a simple thing, but it goes a long way. First thing you can do to help is to comply with your handbook policy. And anytime, again, I cannot stress enough, anytime there's an incident that occurs, you have a responsibility to address that immediately. One way you could do that is by taking the claim down initially. Do not require them to write a statement. You as a supervisor or manager organization, do take the statement. Write down exactly what they're saying, stick to facts, not opinion. If they say, well, he made me feel or she made me feel, say what did they say, what did they do? Try to give facts, not opinions. And make sure once you're done with documenting what the initial complaint or claim is, repeat it to them so you make sure that you're not missing any of the details. And support the victims, follow up with them, make sure that this has stopped. Because the number one thing people want is when harassment occurs is to make it stop. That's all. Everybody just wants to do their job and earn a livelihood. Sometimes you might be asked to serve as a witness, or given what facts you may have, you may be asked to cooperate in an investigation. Please do not withhold information because it might cost the company a big financial lawsuit. Let's talk about some of the impacts of harassment and discrimination in the workplace. There are many, right? And not most of them are good. So when harassment occurs, we have the big financial ones, right? The lawsuits, the financial settlements, legal fees, et cetera, et cetera. Well, think about when there's a harassment issue and somebody is let go or they resign because of a hostile work environment. Think about the cost it takes to replace the individual. All the dollars you're spending per hour that you could be working, time that you're being paid for, that you have to screen candidates, you have to interview them, and the whole time that job is not being done, somebody else has to step in and pick up the slack, so to speak, right? The overtime cost and impact might have on you who have to step in. And then when you have somebody offered and hired to take the job, think about the cost of training somebody. You're not getting that return of investment until they actually start working. So it can be expensive, right? All the costs that we're talking about. And the bigger you are, think about the negative publicity. We talked about Joe Paterno, Jerry Sandusky, Bill Cosby. He was just recently guilty of sexual harassment, right? What a legacy, and what a way to tarnish it. Harassment also prohibits any performance and productivity. It affects it. If you think of your team, again, not just the individuals who are directly involved, but everybody else in that environment, it will cut into your productivity, might cause turnover, and it will have severe morale issues. So who is liable? Organizations and supervisors typically. So for organization, what can they do to prevent this? Well, they take a strong stance and be proactive. Train your frontline defense, the managers and supervisors of your employees. Make sure that they're not committing any quid pro quo or hostile environment type situations by being engaged, by not failing to respond or monitor those complaints. So having trainings like this, making sure handbook policy is updated, distributing that, having people sign that the laws receive it. Every time something happens, you address that claim. These are all steps you can take to build a stronger defense. And because you supervisor and managers are agents of the company, you are held to a higher standard than anyone else. You have to lead by example, and you have to protect the company from exposure. Here are some tips on how to handle employee complaints. Have an open door policy. Encourage people to come to you. Build that trust and relationship with your employees. I said it before, always, 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 no matter how busy you are, please do not ignore a complaint. Please don't tell them to come back later. Document that claim because you never know how severe or pervasive it could be and what the cost might be. If you are not sure of your role, then once you documented the complaint, make sure you report that to your HR professionals so they can take the next steps and plan it out with you. Don't have a chain of command that has to be followed to a T. If an employee is not comfortable going to a certain command, have an environment that they can go to any manager or upper level management and bypass the normal chain. Don't promise confidentiality because there might be witnesses that you might need to reach out to, harassment discrimination claim. So don't ever promise that. Have a balance because there might be that need to investigate. And number one, last but not least, protect everyone's rights. So when is an investigation necessary, right? Sometimes a person, the accused might simply say, oh, you know what? I didn't know that joke was offensive. You don't have to do an investigation, right? Don't waste time. Document that this happened. This is what the claim stated. This is what the accused stated and acknowledged. And these are steps that they will take to remedy the situation and follow up. However, sometimes it might be he said, she said type situation where you might have to do investigation. The key thing here to make sure that you don't drag this investigation out, again, once you initially take the claim down, that you respond in an appropriate time. But you make sure that you have all the right information to properly conduct an investigation, and you have taken steps to resolve it. Sometimes with an investigation, it might be a safety concern. You might have to perform unpaid non-disciplinary leave, depending on what their classification is. So that might be a step you need to take so that there's no further violence type scenarios that might happen. Make sure you identify and have a process of how the investigation should be conducted. Have you laid out all the plan, the steps you'll take, all the individuals identified, all the facts you need to gather, et cetera, et cetera. So here's some really great examples of questions you can ask during the investigation. The first one is for a question to the person who's making the complaint. You should ask something along the lines, who committed the alleged harassment? What happened? When, where, and how did that happen? How did you react? How did the harassment affect you? The key thing here when we're looking at these questions is that you have a system and process to ask the same questions so that you're conducting fair and consistent investigation, right? So maybe put this in a packet together to distribute to your manager supervisors, or you can put this in your HR folder of what the procedure is like. Some questions, examples for the alleged harasser. You obviously want to get the version. Sometimes we're inherently biased to what we hear first, and we might be sympathized or empathetic towards that individual. But there's always two sides to the story, right? So you have to get the other person's perspective. Sometimes you might find that the questions you ask, people are reluctant to share information, or they might be a little vague, or if they're not making sense, to you in responses, that it's your duty to dive in deeper to get an answer out. There's some questions to ask the witness. What did you see? When did this occur? Did the person complain to you? What did they say? You want to look for inconsistencies, right? Throughout all this process. So when you're evaluating all the information, right? Let's say that you might have to look at if you guys have a recording type environment, then audio, video recordings you might have, of course, in accordance with state law. Any other facts like timesheet records, was the person working that day, scheduled to work, et cetera, et cetera. Any other facts or information that might help you with the investigation. So first thing you want to look is can this occur? Is this reasonable? Was it plausible? For example, if the individual is on vacation and can show that they want a trip to Alaska or what have you, then maybe physically they weren't able to be on site yesterday, right? So is it plausible? Look at the demeanor of the speaking when you're questioning them. Are they being truthful? Do they look truthful? Is there any motive they have to lie? Maybe there was what if it's between an employee and a supervisor? Or maybe employees envious of somebody else who had a promotion that they wanted, right? So is there a motive that they would have to lie about this and make up these statements? And are they working with you throughout the investigation? Are they being helpful? And then, you always want to look at the past record of the individual too, because you want to identify patterns. It's hard to prove that a claim has been made with bad intent. However, if you have a pattern of claims where, there was no proof or evidence supporting that claim, then you can show a pattern to, show maybe behavior or attitude towards a person, individual, organization. Once they have all the facts gathered and analyzed all the facts, you want to make a determination. Yes, this person did, or no, that person did not. And then think about the steps you need to implement to remedy the situation. Maybe that might be just training. Maybe there's a write-up. Maybe there's a suspension, or maybe if it's a very severe issue or incident, you might have to terminate the individual. But there are those instances where, as I mentioned, say one person's word against the other, and you may not find any facts to support the claim. Doesn't mean that the harassment and discrimination has not occurred. It just means that you don't have enough proof. Still, in that case, as in the case of when you do have proof, you have to file a report so it shows that the company did take some action to address the claim. Even though the findings did not show that they supported the claim, at least in a court of law, it will show that the company did take action, that it does address all complaints. And that'll be your best defense in a situation like that. You want to inform all the parties once you've decided on an outcome. You don't have to discuss details of the disciplinary action if that is the direction that was taken to anyone involved. But you should inform the parties that you've taken steps to remedy the situation and ensure that there's some follow-up to make sure that it's not repeating itself. Before you take the corrective action, though, you should consult with your manager or HR professional to make sure that you're not violating state laws and that it's consistent with anything else the company has done in the past. Right? Make sure that whatever you've decided to do is effective. You want that behavior change immediately. Okay. You want to make sure that the person does not have any adverse impact on their employment because of this. Or the victim, I'm sorry, I apologize. The victim is not adversely impacted by this. The main thing is that people simply want this to stop. And that's the key. There are very strict retaliation laws. In fact, retaliation cases for the first time last year and the year before surpassed any race-related claims to the EEOC. Equal Employment Opportunity Commission has shared that race, which used to be leading all complaints and claims in their organization, has now been surpassed by retaliation. So it's important to understand what this means. You have to make sure that you don't take an adverse action against individuals simply for filing a claim against whoever it is or whatever happened in an organization, right? Adverse action could include discipline, demotion, termination, salary reduction, changing job duties, anything of that nature. To avoid a retaliation lawsuit, you want to educate yourself, your employees, and you want to make sure that people are, again, open to having a file a claim with you, an open door policy, maybe having a confidential meeting area where you could go take the address the claim private. As with any other disciplinary action, any employment that has an impact on someone's employment, you want to document performance issues, warnings, complaints. This is how you build a defense against a wrongful termination case or a discrimination or harassment case. If you don't have documentation on why people are being promoted, why somebody has been terminated, why somebody has been hired, what job duties job descriptions, right? That they're set expectations to, then you're putting yourself in an exposure type situation. So it's important to have the documentation. That's something that HR professionals keep promoting everywhere. Here's some preventative actions you can take to make sure that you're having an environment that's free of harassment, discrimination. Have a clearly written company policy. Make sure your handbook is updated. As a manager, again, be visible, be proactive and not reactive. Here's a sample of the harassment prevention policy. I think it's pretty standard with most companies. The important thing is to make sure that they're updated to comply with the law. As a manager, supervisor, make sure you have a proactive management style. So, please do not be reactive. Again, I said it before, be proactive. When we talk about training, why is it important? Well, it's not only documenting what your company's practices are to ensuring that you foster that type of culture, but it's also that you want to provide information to everybody of, what could be harassing, set those expectations, right? Just communicating those expectations to create that awareness, right? You managers and supervisors, again, you lead by example. You're an agent, a steward of the company. You play a critical role in all this. Signs that some harassment discrimination might be occurring in the workplace. Somebody who had really good attendance and now is having issues, right? Somebody who's constantly avoiding working on a project or interacting with another individual altogether. An individual who's really a good high performer and now they're declining their performance. These might be all signs that something has occurred in the workplace. So steps you can take when an employee complains. You need to respond immediately in a timely manner, and you need to take every complaint seriously. Be fair. Again, the person who comes with the complaint first, you might be biased to them, but investigation might show that maybe it was not a fair claim, or the right claim. Be supportive. Always be supportive. Reach out to victims. Do a lot of follow-up. Show empathy and respect. And document. Again, I cannot stress how important this is. It is what may make or break lawsuit claim. How many of you experienced a situation where an employee comes to you with a complaint and says, "Oh, don't worry about it. I don't want you to do anything right now, but I just thought you should know." What do you think your responsibility is? Absolutely have to respond. Absolutely have to take action. Number two, there's no such thing as an off-the-record complaint. There isn't. Every complaint that's made to you as an organization manager, supervisor, is a complaint that you may need to investigate. So what happens, right? What happens next after all this? Well, you make sure that the victim is aware that not always may the individual they're complaining about be imposed the disciplinary action that they're looking for. So initially, when we go back to the questions I had shared with you earlier, one of the questions was, what would you like to see happen? Well, the person maybe they have a very low tolerance for joking about a certain background or protected class, and they want you to terminate that individual. Well, that is not the answer, right? Maybe the person needs more training. You want to make sure that the offender, once you have the investigation results and you're carrying out the corrective action, the offender acknowledges that that behavior has to stop immediately. And you want to make sure that you are committed as an organization to make sure that the next time something like this happens, you have a more severe disciplinary action imposed to the individual. Bottom line, as I mentioned before, you are not obligated to discuss details of discipline with an employee. All you can tell them is that, well, we've addressed it and we made sure that we've taken the steps to make sure that it doesn't occur again. If it continues to do so, please come to us and let us know, and we will make sure we take corrective actions. This is a brief slide, I think, and is included in this presentation. Some tests for spotting harassment. So you think about how, when you're not sure, or when you're speaking to employees or conducting training, or there's a session, share it with them too. When you're not sure about harassment or discrimination, right, jokes or comments, things like that, well, ask them or ask yourselves, would you act that way in front of your child or your parent, right? Or the worst case, would you like to see yourself in the news? Bill Cosby, you know, unfortunately, is an example of that. When you have harassment-free workplace, right, and you take all the necessary steps to make sure that you have preventing a discrimination, harassment in your workplace, you'll see people who are happy and engaged, and they're buying into the company. Policies that you might roll out will be easily supported by the employees, even though they may not agree with it necessarily, right? They might have improved morale and the productivity. There'll be smooth workflow. People are harmonious, they'll enjoy working together. There'll be that reduced turnover and liability to the company. Thank you all for attending. We do have some upcoming seminars. You can get copies of this presentation by contacting us at hrsc@alphastaff.com or by contacting the phone number 888-335-9545, option 8. We have a webinar coming soon, October 11th, on recent employment regulations and risk. It's presented by our attorney firm, Jackson Lewis. And thank you all once again for attending.